and it is supported by my client's director's affidavit, Christian Pataturia. My Lord, I will not go into too many of the grounds on the face of it, but my Lord, to point out a few salient issues. My Lord, the application dated starting with the 28th of January 2022, followed in quick succession by my learned colleague Ms. Kimeto's application amended on the 31st of January, together with other creditors who filed on or about the 10th of February, my Lord. All of them are seeking the removal of one Mr. P.V.R. Rao, who is the first respondent before your Lordship. My Lord, Mr. Rao has, in affidavit sworn on the 22nd of February in these proceedings, responded. He has filed several different affidavits, my Lord, responding to each of the applications for his removal. And my Lord, the first point to note is the dishonesty that Mr. Rao displays to the court. And my Lord, I'm extremely, I think it is either coincidence or the fate of how things happen, that my Lord happens to be the same person who is dealing with the insolvency and the case by 4 or 5 creditors in E004 of 2022. My Lord, in E004, he argues he's filed preliminary objections on jurisdiction as well as the other respondents have filed preliminary objections on jurisdiction. My Lord, in that, they tell you, don't listen to these people here. Let them go to the insolvency. And then, my Lord, in the insolvency, he tells you, don't listen to these people here. Let them go to Lambert. So, my Lord, this ping pong of which court has jurisdiction, clearly, my Lord, is dishonest. Because the ultimate thing is to scuttle any questioning of his conduct in leasing the assets of Mumias. And my Lord, the two principal bases on which we are asking you to order for his cross-examination is one, his affidavit of the 18th of January 2022, my Lord, in which, my Lord, you, on the 19th of November in this case, you told him to produce a detailed statement of account. In his response filed on the 22nd of February, my Lord, he tells the court, he actually regurgitates the exact question that my Lord had, or exact order that my Lord had framed, which says a detailed statement of accounts, a detailed statement of receipts and payments made and received respectively. And my Lord, he quotes that, but then says, Section 351 of the Repealed Companies Act. He then quotes a repealed law to justify why he filed only 4 pages of accounts. Sorry, my Lord, Senior Counsel has ordered me to remove my mask, so I must comply because I'm not very audible. So,
thank you, Senior Counsel, for coming to the aid of the court.
So my Lord, the point I'm making is when you tell somebody as a receiver, an administrator, to account to the creditors of Mumias, and he only submits 4 pages of accounts, is that conduct being transparent and accountable? Because, my Lord, in your ruling, and it's widely available and quoted separately by this gentleman called Rao, he keeps saying that you are the one who told him to submit these accounts. So, my Lord, we want to question Mr. Rao to ask him what his understanding of the word detail is. My Lord, when you go to those accounts that he has filed, my Lord, you will see certain portions which I have quoted inside the application. He is donating. He has made donations. So, my Lord, legitimately, a creditor can ask, what donations are you making when a company is insolvent? We have asked these questions and he has refused to respond, my lord. My lord, in fact, he then goes to have a line entry called facilitation expenses. My lord, what are these facilitations? Are they bribes? We have asked him, he has refused to respond. Then, my lord, you will find an entry called excise duty. Instead of being put as a liability, it is being put as an asset. How can excise duty that is supposed to be paid to KRA be an asset of the company? My lord, he has paid millions of shillings to lawyers who he has refused to disclose and be transparent about. My lord, I have had the benefit of seeing affidavit by Mr. Meto, the petition by Mr. Wekesa, by Dr. Kaminwa. They are all here as legal counsel who have acted in Mumias during its times and its heydays. And they haven't been paid. And they are also saying, we want to know who these lawyers are that are being paid. Then, my lord, you have about 21.9 million as a valuation report. My lord, we have questioned him. What is this valuation report? Can we have it? He says, no, these matters are before the court. Now, I want him to tell the court how that matter of a valuation report is before the court. My lord, as a creditor, we are entitled to all these documents because, my lord, that valuation report is probably going to demonstrate to you something that he wants to hide. He is treating as though all this is his personal property and that he was doing this for his own benefit. My lord, in E004 of 2022 and even in these proceedings, to date, he has not produced the lease that he alleges to have given to the fourth respondent in these proceedings. My lord, this is a question the court asked him, and from the bar, his counsel's response was, oh, my lord, that is not disputed. The point, my lord, is not about dispute. It is about, this is not your property. You cannot be leasing away the asset that several hundreds of thousands of creditors have a right over and refuse to disclose that document. Indeed, my lord, my client believes that that document either does not exist or is being prepared as this case goes along. For these reasons, my lord.
Yes.
And my lord, I would trouble you, my lord, with looking at some of the salient documents that we have filed together with this application and that are also in proceedings in the Lambert case before your lordship. And my lord, just to look at page 61 at the bottom in red, my lord, of the bound document I sent, I handed over. My lord, this is a document dated 21st of December 2021 by the fourth respondent. My lord, in that document,
You're looking at it?
page 61, my lord, at the bottom in red, and it is a document on a letterhead of Sarai. And my lord, that document is dated 21st of December. It then refers to subject is security deposit of 69.6 million. My lord, what is important? It is saying this is in reference to point number 5 of the duly executed sublease between Mumias Sugar and Sarai. My lord, the beauty is that sublease is dated 22nd December. So on 21st, this company is referring to a document that has not even been executed. So my lord, Sarai will be asked and Rao will be asked. So on what date really was this executed? And then, my lord, the next page, which is page 62, my lord, this is a check that the fourth respondent then forwards through that letter of page 61. My lord, look at the drawer of that check. It is not Sarai. The drawer is a human being. It's not a company. So, my lord, several allegations have been peddled about the highest bidder's capacity, including mythical allegations of inability to perform. Who actually has the inability to perform here? Is it Sarai or is it the highest bidder? So, my lord, those questions will be put to him, because how did he accept a personal check from somebody who is not Sarai? And then, my lord, to top it up, my lord, the handover letter, which appears at, sorry, my lord, I believe it's in the previous pleadings, my lord, but there is a handover letter dated 22nd of December. My lord, that letter as well talks of the lease that has been executed. So, my lord, Mr. Rao will be asked, so on 21st, Sarai writes you a letter, refers to a lease that was supposed to be executed the next day, and the lease is dated 22nd. In fact, that lease, only a few pages have been produced, and I believe they're in the Lambert case. But my lord, that lease is dated 22nd. So at what point did his lawyers prepare that lease?
Anything else?
Yes, my lord, just 1 minute. And my lord, I think to cap this, my lord, all those inconsistencies that we have said exist are part of the court record. And finally, my lord, there has been no response to that application. The only response is a preliminary objection. My lord, the less I say about it, the better. But importantly, without any disrespect, my lord, it does not cite a single provision of the law on which it is grounded. Preliminary objections, my lord, are trite law under the Mukisa case, that you must cite the law and it must raise a fact, its legal point. He is saying that the applicant is not a creditor. He has already responded to the application of 28th January. Now he is collaterally trying to attack the applicant's status before the court through the cross-exam. Why? Because he wants to avoid accountability. That's the simple answer. None of those points raised in the PO raise any question of law. He has already responded to our application, and now this is a way to collaterally attack the applicant's status. So, my lord, on those grounds, I believe that the important thing is for your lordship to order this person's cross-examination, because then it will become clear why we want to cross-examine in our ultimate application of 28 January. Thank you.